Representation before the IRS is mostly a credentials question. On the EA exam, they love asking who has unlimited representation rights versus who is limited to a narrow specialty. If you can separate unlimited from limited scope enrolled and then match OPR versus RPO duties, you'll pick up easy points. Unlimited representation means you can represent any taxpayer on any federal tax matter before any IRS office. There are only 3 credentials in that club: attorneys, CPAs, and enrolled agents in active status. If you see enrolled actuary or enrolled retirement plan agent, your antenna should go up. Those sound impressive, but they're not unlimited. Here's how the exam tries to trick you. It uses the word enrolled to bait you. Enrolled actuaries are enrolled by the Joint Board for the Enrollment of Actuaries, but their practice is limited, mainly to employee retirement plan areas under specific code sections. Same idea for ERPAs, enrolled retirement plan agents. They're real, but their authority is narrow and retirement plan focused. Now zoom out to oversight. The IRS Office of Professional Responsibility, OPR, is about conduct and discipline under Circular 230. Think investigations, disciplinary proceedings, and sanctions like censure, suspension, or disbarment. If the question is about ethics violations or whether someone can be sanctioned, that's OPR territory. The Return Preparer Office, RPO, is the administrative side for preparers. They issue PTINs, act on applications for enrollment, and administer the annual filing season program, including testing and continuing education for designated groups. Quick exam shortcut: OPR equals discipline, RPO equals PTIN and program administration. One more high-yield nuance. Not every OPR action kicks you out of practice. A public censure is basically a formal reprimand. Suspension and disbarment, though, remove or restrict your ability to practice before the IRS. So when you see disciplined, don't automatically assume can't represent. Read the type of sanction. Which of the following disciplined practitioners may represent clients before the IRS? One option is a practitioner who has been disbarred. Another is a practitioner who has been publicly censured by OPR. Another is a practitioner suspended from practice for 2 years. Or the last option says none of them may practice before the IRS. Think about it. The correct answer is the practitioner who has been publicly censured by OPR. A public censure is a reprimand, and by itself, it doesn't prohibit representation. The tempting wrong choice is none, because the word disciplined feels like an automatic ban, but suspension and disbarment restrict practice. Censure alone does not. Which of the following is an offense that could lead to practitioner sanctions by the OPR, according to Circular 230? The options include gross negligence, gross incompetence, gross delinquency, and gross recklessness. Which one is actually a recognized basis for OPR sanctions? Think about it. The correct answer is gross incompetence. Circular 230 allows OPR to censure, suspend, or disbar a practitioner for incompetence and disreputable conduct, and gross incompetence fits that. A tempting distractor is gross negligence, because it sounds like an ethics standard. But the tested Circular 230 wording here is incompetence.